Thanks for tapping in with Street TV. I have an update on the arraignment of young Ant Jefe and his co-defendant Johnny Gray. I am doing this video to provide a little bit more clarity than the previous one that I did with Angie Smalls. I understand there was a lot of complaints about the information, but I have the notes. I got the notes of what happened in court on last week, and let's go over it, and hopefully that'll bring you some more clarity to this situation. Now, young Ant Jefe and Johnny Gray both came into arraignment court, and they came in from separate locations within the Los Angeles County Jail. Young Ant was wearing a blue shirt, a LA County blue shirt, and Johnny Gray was wearing a yellow shirt. Now, the yellow shirt means that an inmate has been given some sort of medical classification. It could mean that he has mental illness. It could mean that he is under some medical supervision. It could just mean that someone is playing a role. I don't know the specifics of it, but the yellow is a mental classification, and the blue LA County shirt is for general population. All right, so let's get into what happened in court after the two brothers appeared. Now, there was an attorney, I guess an attorney swap that Ant did. He was assigned a public defender from the alternate public defender's office, and that attorney was present, but also Ant's private attorney was present as well. So they were swapping out. And his private attorney, named Loyst Fletcher, told the court that he's taking over the case, and the judge excused the alternate public defender.
So today, Mr. Shelmon was arraigned. In other words, he entered a plea of not guilty. I substituted to the case as well, and subbed out the assigned public defender.
Now, Mr. Gray has an attorney named Armando Rodriguez. He is a bar panel attorney. Remember, I spoke about this on a previous video regarding the no jumper beating case. It's when the public defender can't do the job, the alternate public defender can't do the job, there's some sort of conflict. And when that occurs, both with the public defender's office and the alternate public defender's office, they have a list of private attorneys. They're called bar panel, and they work on behalf of the public defender's office, but they're private attorneys, which means that he doesn't have to pay for that attorney. So both attorneys expressed to the court, both attorney Rodriguez for Mr. Gray and attorney Fletcher for Shelmon, both expressed concerns about not having discovery. And initially, attorney Rodriguez, this would be Johnny Gray's attorney, said they wanted to postpone the arraignment till the 26th because he was lacking discovery. So the judge asked Mr. Gray, is that what you want to do? Do you want to postpone this arraignment because of a lack of discovery and postpone it to June 26th? The judge reminded the defendants that they have a right to a speedy arraignment, meaning you can have your arraignment right now, or we can do it on the 26th. And there seemed to be some disagreement between Johnny Gray and his attorney, because the attorney wanted to postpone this arraignment to the 26th. And then they had a brief conversation off the record, which we couldn't really hear. And then once the attorney came back, Rodriguez told the court that Mr. Gray does not want to waive time for this arraignment, and they proceeded to go forward with the arraignment. Attorney Rodriguez actually ended up telling the court that Mr. Gray no longer wants to waive time. We are asking for a preliminary hearing. within the period because, and then he also said, I'm still lacking discovery. And, but he's hoping to get the discovery from the prosecution before the preliminary hearing. So I thought that disagreement between Johnny Gray and his defense attorney was kind of interesting because you could tell that Mr. Rodriguez, the defense attorney for Gray, did not want to waive. I mean, he wanted to waive. He wanted to waive time to June 26th so he can get the discovery, obviously, which makes sense. If you don't have the discovery, there's no need to rush a case. For some reason, Johnny Gray does not want to wait till June 26th to have the arraignment and then perhaps have his preliminary hearing sometime in July or maybe August. He even spoke to the court and said that he did not want to waive time. He's got other cases too that he doesn't want to waive time on those. He wants to get this process going because he wants to go home. He literally said that he wanted to go home. And that's an indication of a disconnect between his defense attorney and the client, because the attorney wants to gather the information and Mr. Gray wants to go ahead and move forward. So the judge told Mr. Gray, you have a right to have your preliminary hearing within 10 days. You have a right to have your arraignment right now. And then you have a right to have your preliminary hearing within 10 days of the arraignment. So they entered pleas. Mr. Rodriguez and Mr. Fletcher entered not guilty pleas on behalf of their clients. And then the judge set a date for preliminary hearing. When the judge says we are 8 of 10, that means that they're going to set the preliminary hearing on the 8th day after arraignment, even though you have 10 days. They don't want to schedule the preliminary hearing on the 10th day because there's a chance of an unforeseen circumstance that prevents the preliminary hearing from happening. And if that recurs, then you end up violating the defendant's right. So rather than waiting to the exact 10th day from arraignment, they do 8 of 10 in this example. And 8 of 10 means we're going to do it on the 8th day. We still got 2 days in case something happens on that 8th day. So that 8th day is going to be June 17th, 2026. And that will be the preliminary hearing. They will be having that preliminary hearing in another department. And then after the arraignment, young Ant Jefe's attorney, Loyst Fletcher, had a few words to say outside of court.
I have not as yet received the discovery in the case. That would include the complaint, include any documents or narratives, etc., police reports supporting the charges. So I have yet to review that and do a deep dive into that. So I have very limited facts at this point.
So there you hear it. Young Ant Jefe does not have a public defender. He has a private attorney. But I would also like to add that at this stage of the game of a case, it is quite all right to have a public defender. There's no need to spend additional money on an attorney when it's just an arraignment. There's not much going on in an arraignment. You're just pleading not guilty. And even when you go to preliminary hearing, you don't really need to be that concerned about your case when it's preliminary hearing. All the state is going to do is present a little bit of evidence so that the judge can bound the case over for trial. At that point, you'll have a better understanding of your discovery. You'll have a better understanding if you want to fight the case, or maybe you can determine whether or not you'll plead out. But there's no need to retain a private attorney this early in the game. So I don't think there's anything to be embarrassed about. A lot of people want to shame people for getting a public defender. But at this stage of the game, at this early point of this case, private attorney is not necessarily needed.
Currently, he's being held at Twin Towers he is in good spirits. He's happy that he has hired a private counsel and that I'm on the case. And he's making $2 million bail is the schedule for a murder one, which is what Mr. Shelmon is being charged with, but I believe he is being overcharged. So I believe the bail is substantially too high, and I'll be addressing that with the court.
Now that's interesting. The defense attorney believes that young Ant Jefe is being overcharged. We did hear Ant Jefe call in.
I don't even know what's going on. They just identified me and two other people. One of the people, he already got a DA reject the first court date. So they just identified who they can identify, you know what I'm saying? But it's like you a gang expert, so how you can't identify nobody else, but you identify me somehow, some way. So basically, being that I'm the most notable person out there, they're trying to like basically put, I guess, that narrative together that I had somebody do something. But so basically, I'm gonna put this out there because this is public knowledge at my court date. So my first court date, before I can hit my paid lawyer, the public defender came to me and explained what was on the paper that was from the camera, and basically the public defender was like, "Man, look, this is crazy. I don't know how they charge you with murder just from what's on this thing." You know what I'm saying? And from my understanding, it's just like basically, you know what I'm saying, I'm locked up and everybody else that got locked up that they can identify is younger than me. So basically, they trying to like, I guess, go with this narrative that I had some younger dudes do something that I didn't. Like, bro, these dudes have been out here since 6 o'clock hanging out. I pulled up at the store at 9:30 to get some tissue. I don't know what the going on, what have been going on. You know what I'm saying? I don't know. So that's why I'm like, motherfuckers keep going with these narratives.
And also, even in the probable cause statement written by the police officer, there seemed to be some sort of contradictory statements. One where he was saying that young Ant was trying to de-escalate or stop the situation between an unidentified person that I called suspect 4 and the victim, Carl Welch. And then in the very next sentence, he says that young Ant assaulted him. You know, it seems a little unusual, not impossible, but it definitely supports the idea that maybe there is a bit of overcharging, but we haven't seen the video. And also, let me say, any of the videos that you've seen on the internet that have suggested that this was this incident, untrue. There are no videos floating online as of now that represented this incident.
It's my understanding there is a videotape. I don't know what it depicts, but I do know, or I should say, I do understand that based on the opinions of the public defender, that the video substantiates my opinion that he is being overcharged, and this is not a murder one case.
So the private attorney Fletcher spoke to the alternate public defender, who actually has seen the video. Now, remember when young Ant called in, he said his public defender, his attorney at that point, had already saw the video, and they had some issues with what they were claiming young Ant did in this situation.
The public defender came to me and explained what was on the paper that was from the camera, and basically the public defender was like, "Man, look, this is crazy. I don't know how they charge you with murder just from what's on this thing." You know what I'm saying? And from my understanding, it's just like basically, you know what I'm saying, I'm locked up and everybody else that got locked up that they can identify is younger than me. So basically, they trying to like, I guess, go with this narrative that I had some younger dudes do something.
Now, that parking lot has 2 cameras on 2 high light poles. So there may be actually more than one angle of this incident captured on video. But thus far, no one has seen the video except for, obviously, the prosecutor and the original defense attorney for young Ant Jefe. Even his current attorney, Mr. Fletcher, hasn't seen the video yet. But he spoke to the public defender on it, and it seems like she believes that what she saw in the video does not line up with the charges.
based on the charges, he's facing life without parole, based on what the charges are and based on what the prior record is. So that is the worst possible case scenario, obviously.
And there you have it. That clip is from Anita Bennett from Urban Hollywood 411. So go tap in with her channel if you want to see the whole interview. And thanks for tapping in with Street TV.